And actually, I'm just going to repeat myself that Andrew, that it is such a privilege at the Environmental Law Center to work with public interested citizens such as yourself, and just what an exemplary act of citizenship it is that you've done this intense research. So we're going to move on then to Morgan Blakley, who's our last speaker. Morgan is a mountaineer, an ELC alumnus, and a former ELC associate and lawyer. His practice focuses on litigation, though he assists clients with all manner of legal work. He spends his free time gallivanting up mountains and down rivers. He's been practicing law since 2012. Before law school, he worked in sundry fields, including construction, forestry, oil and gas, and first aid. And Morgan was counsel for the Outdoor Recreation Council on the Douglas Lake Cattle Company and Nicola Valley Fish and Game Club case. And Morgan, did you win the Rocky Raccoon t-shirt?
No, I think you gave it to that completely undeserving fop named Ethan.
Yeah, your best friend.
I'm still bitter.
I think we'll ship you one in view of your service here today. Yeah, so Morgan, take it away.
All right, so I'm going to shift gears a bit from the other presenters and deal with just some kind of what I'll call nuts and bolts of some public interest, what I'm generally think of as public interest access litigation. I'm going to deal with standing, intervenors and parties, security for costs, and then some miscellaneous issues of evidence that may help you, I hope, in your practice dealing with these sorts of lawsuits. Standing, let's start there. So I think most of the litigation that you will end up taking on through EDRF or pro bono or whatever is going to be public interest litigation. I'm assuming everyone's familiar with that. Generally, to go to court and to argue a case, you have to have public interest standing or you have private standing. Private standing generally means you have a direct personal legal stake in the outcome of the lawsuit. Public interest standing is more general, and it's in 2012, I guess that's not recently anymore. In 2012, the Supreme Court of Canada broadened the test for public interest standing and made it much more accessible to the general public to get standing to litigate issues such as this. So if members of the public want to establish land access in court, generally they're going to have to get public interest standing to do so. The test for public interest standing it's settled now. It's Downtown Eastside Sex Workers United Against Violence. That's the leading Supreme Court of Canada case on that. And it was recently, I'd say, affirmed and succinctly summarized in the Council of Canadians with Disabilities case. That's a 2022 Supreme Court of Canada decision. If you haven't read it, it beautifully sets out the test for standing in like 4 paragraphs. It's well written, it's unanimous, it's a great decision. The 3 aspects of standing are that there's a serious justiciable issue, that the person bringing the case has a genuine interest in it, and it's a reasonable and effective means of bringing the lawsuit. I'll dive into those in a little bit more detail in a second. I'll just note, plead standing up front. I've now tried several times without success to leave the issue of standing out for reply, and I'm being forced to amend the pleadings to specifically address public interest standing. I don't like that approach. I think standing should be presumed like jurisdiction, but I've lost. So if you're going to be pleading a case, you might as well just plead the facts and the law necessary to establish your standing off the get-go, and maybe you won't get in some of the fights I've gotten into over it. Going back into the test, right? It's a 3-part test. There's a serious justiciable issue. Often, I think that's a very, I'm going to call it a very low bar. That's you're not asking the court to adjudicate something it can't adjudicate. So who gets to play on which hockey team, whose bridge hand was the best, things like that are not justiciable. They're not serious. The court's not going to deal with them. Generally, I think public interest standing, especially to roads and highways, is going to be considered both serious and justiciable. Those 2 words have specific definitions in the case law. The Council of Canadians case lays that all out. I'm not going to dive into nitty-gritty details of the law. Genuine interest, no busybodies. This, I think, basically goes back to the law of maintenance and champerty in the olden days, and now it's just, you know, they don't want busybodies. I don't think, again, I think this one's a pretty low threshold. All the fights on public interest standing, except for one perhaps that I'm involved with now, usually deal with the third factor, which is whether it's a reasonable and effective means to bring the lawsuit to trial. You're going to prove genuine interest more or less by showing that your organization or entity or group has a long-standing engagement with the issue. That's often, if people come to you before the lawsuit's launched, you can help them stack that record. You can give them advice on what they need to do to show they're interested, sending letters to ministers, writing op-eds, being active in the community and social media, pairing up with larger organizations if you're working with a small outfit to try and get the issue addressed, doing with it over a long period of time instead of just popping up out of the blue. Sometimes it will be an out of the blue issue. Someone goes and deactivates a road while it arises out of the blue. Maybe the group isn't otherwise a public interest organization and that's it. But you do want to think about and try to make sure that your client has a genuine interest. So like I said, I think the fight's usually around the third factor, which is is it a reasonable and effective means to bring the lawsuit? If you read the Council of Canadians case, I think the court is pretty clear that the test is meant to be flexible and applied liberally, I would say, in favor of granting standing in these lawsuits. Where genuine interest comes up is, and I'm going to talk specifically about a case I'm involved with right now. It doesn't matter that this is recorded. There's nothing privileged or confidential here. 9 Mile Road near Fruitvale. It goes from Fruitvale and it travels down to the Pendahe River. That road was used by the public for years, decades, probably originally as a trail in the late 1800s. So, 1900, quite a long period of time. I think it was around 2018, a landowner along the road tore it up. Cars can't get by anymore, and it's basically no longer used. One of his neighbors, named Bruce Uasiak, brought a lawsuit to try and get access through that property. He lost. And that led to the genesis or the creation of the Public Access Protection Society. I'm expecting that. And so now that society's been advocating for access to this road, for access for Mr. Bruce Uasiak, as well as some other roads and trails. But it's going to be a live issue as to whether or not the society is basically a legitimate organization that's bringing a public interest litigation, or if it's just a false front for Mr. Uasiak's failed lawsuit. So that's one circumstance where the issue of genuine interest has come up for me, where you basically have a society formed to deal with an issue that was lost in another case. It was only lost in the most general sense because the issue of whether it's a public highway was abandoned by the lawyer who had the file. But that's, malifides and maintenance and champerty. Those are the sort of things that I think will get you into trouble on whether or not there's a genuine interest. The reasonable and effective means test. I'm only going to make one point on this, and that's that the court specifically says they've changed from the most reasonable and effective means to a reasonable and effective means, given practical realities. So you don't have to prove that, it's the only way that this is going to get resolved by the court is in this particular lawsuit. You have to show the court, convince the court that the lawsuit you're presenting is a reasonable and effective means to bringing it forward. So keep that in mind. That's basically the outline of the test for standing. It's something you have to address. You should plead it. You need to plead the facts in the law, of course. So do so. Another one that this is a bit unique, but one of the, I'd say, as a public interest litigant, the way you bring facts to the court is a bit different. It's not your dispute, right? It's not a criminal trial or a civil trial between two private parties. And to prove that what you're bringing is a reasonable and effective means, the court is often going to look at the pleadings. So plead your facts in detail. Some lawyers don't. They'll plead very summary facts. They'll plead very summary law. That can get you in trouble. If you really have thought your case out in advance, you should be able to more or less, I think, write your factum in your notice of civil claim. And if you can do that, you're less likely to get in trouble on these issues and either have an unnecessary application or be forced to amend if you lose an application or anything like that. So I think it's really important up front to make sure your evidentiary record as a public interest litigant in all but the rarest of cases is very thorough. The one exception is if your case is based entirely on legislative facts, which isn't going to happen, I don't think, in a public access lawsuit unless you're just relying on something really obvious like a gazette. That might be one of the few circumstances where it's just legislative facts and you don't have to do anything further. But assuming it's not that, going the route of the last presenter and having Andrew's very detailed, thorough research really will go a long ways towards showing the court that your client should be allowed to present its case, because public interest standing is discretionary. And if you walk in with a sloppy case and you don't know your case on, say, an application to strike the claim, if you're not already laid out, you're much more likely to lose. You're just not going to look good for the court. They're going to exercise their discretion to not grant standing or to strike the claim. So to the extent you can, have your ducks in a row before you file your civil claim. And I would encourage all lawyers to file very detailed notices of civil claim. So that's what I'm going to say about standing. Next little bit that's kind of related to standing is intervenors as opposed to parties of record. This comes up a lot in the calls I get. I get calls from someone or some organization that says, they'll say something along the lines of, hey, we've just been made aware of this lawsuit that's going to proceed in the BC Supreme Court over access to some road or another. We want our voice heard. We want to participate. They don't, and often what they in fact want to do is they want to intervene, but interveners don't get to present evidence generally. Absent some pretty unusual exceptions, interveners don't get to do that. And it takes a fair bit of effort to talk people down from that position. They can try to get at it as a party, but of course, then they face things like cost consequences and discovery obligations and all of that. And a lot of public interest organizations either can't afford it or don't have the resources to deal with that. And a targeted intervention at the law is much better, but that generally happens at appeal. Not always, but generally it happens at appeal. So it's something to keep in mind with people you talk about. How are they going to come to the court? Do they want to come as an intervener and say this is how they think the law generally should be interpreted? Here's a different, unique perspective from an organization that isn't represented in this trial, but whose legal interests aren't directly affected. So we should be here to, caution the court perhaps on what it says. Or do they want to dive straight in and be a full party to the lawsuit? It's important you think about that and discuss it with your clients. Security for costs. So this comes up especially with newer non-governmental organizations or small ones. If you're representing a large, well-funded nonprofit organization, the issue probably won't arise. But if you're representing a small organization, it doesn't own any real property, it has nothing recorded in the PPSR, which is a personal property security register, you're probably going to get at minimum an email from the opposing party seeking confirmation that your client can cover a costs award, or they're going to bring an application for security for costs. For some small organizations, that could sink the lawsuit. So you need to cover that up front. Establishing an organization just for one lawsuit, not generally a good idea. People try to do that to avoid adverse costs awards. You're going to lose on security for costs. They're going to have to come up with some kind of security for costs. So if, I've heard it bandied about, oh, you want to bring this public interest lawsuit, but you don't want to pay cost consequences, form a new society, have 3 directors, off you go. They're not going to come after you for costs. No, they're not, but your lawsuit's probably not going to get out the door. There's going to be a preliminary application very early in the lawsuit where the other side just asked for security, probably in the ballpark of $5,000 per expected trial day. more or less depending on the lawsuit. If you're fighting an application for security for costs, realistically with a smaller end goal, you're probably arguing about quantum and whether costs should be staggered and when they should be paid. So one of the ways you can deal with security for costs, if you're required to pay it, is convince the court that the amount of security should be staggered. So you're going to have to pay, I'm just picking numbers, $5,000 before examinations for discovery, $5,000 before trial management conference, and then say another $10,000 before the trial starts. So it's a total of $20,000. But strategically, if the lawsuit is going slowly or you're able to delay it on your client's instructions or not, that gives your client more time to come up with that money rather than getting one cost award that says, hey, you have to pay $20,000, $25,000 before you can take any other step in the litigation. Quantum's arguable, right? You can try and argue that it should be more, it should be less. It kind of depends on the nature of the trial. If there's going to be a lot of experts, if there's going to be a lot of oral testimony, it's probably going to be on the higher end. If it's going to be a documentary trial and you're going to need very few, if any, experts, then hopefully you can argue down from that $5,000 a day kind of ballpark figure. So that's security for costs in a nutshell. I just think it's important that people don't think that by creating a nonprofit to deal with a lawsuit, they're gonna be able to have the lawsuit proceed and get out of costs. There are, of course, exceptions. The court, it's a discretionary remedy. So if you can convince the court that the lawsuit is so important that it should proceed anyways, they can decide not to award security for costs, even against a small nonprofit that can't pay a cost award. It can happen, but I think you've got a very large uphill battle in that case. And then, oh, I'm going way faster. Look at that. We'll be done on time, no problem. Admissions are evidentiary issues. I'm going to start with admissions and notices to admit. Please use them. They're a very useful tool. I'm in the process of preparing a notice to admit that's probably going to be 15 to 20 pages long. I am seeking admissions from the province on basically all the documentary evidence I have on an access lawsuit. So we have records from going from 1902 through to, I believe it's the 1970s, including public expenditures on roads and maps showing the road. I'm taking those documents and I'm turning them into a notice to admit, where we're asking the province to admit that, I'm picking some random numbers. In 1945, the province spent $2,000 on the road. And I'm going all the way through all my documentary evidence, seeking all of those admissions. This is very early in the lawsuit. We haven't done examinations for discovery. And then we're asking for the authenticity of all the documents. If they admit the authenticity of all the documents, you still have to get the facts submitted. I think lots of people miss that, and it's important you don't. The simple fact that someone, the province or otherwise, admits that a document is authentic doesn't mean they admit the contents, the truth of the contents of that document. You need to do both. So make sure that you have them admit the authenticity of the document, say a public record of some kind, a public expenditure report, for example. And then for each one of those, you have to get them to admit the facts that you care about from that document. In 1945, they spent $2,000 on this road. We're going all the way through with a notice to admit like that. And it's not just to get the admissions or for the possible consequences if they unreasonably refuse to make the admissions. It also sets up your record just generally, and it's part of the litigation process of trying to show the other side they have no case long before we get to trial, putting the doubts in their mind, even if they don't admit it. So I think they're useful. You need to do them carefully to make sure you're asking for reasonable admissions, not unreasonable ones. And remember that basically all correspondence with the other side is really part of the advocacy that's involved in this. A few other evidentiary issues. Business records and historical records. In these sorts of cases, you're going to often be relying on historical records keep in mind documents over 30 years old are often presumptively admissible as historical records if they weren't used for the purpose of basically in contemplation of litigation. That's in addition to the business records exemption against hearsay. New to me is there's another, I'm going to call it an exception to the rule against hearsay, which is it's actually a reputational rule. It's a rule of reputation dealing with public rights and public resources. Basically, if you have ancient records over 30 years old that speak to the public nature of a road, Andrew presented one. It was beautiful. It was signed. It says that it's a public road. There's an exception in there that basically says that's admissible. It's evidence for the truth of its contents. It's old, wasn't done in contemplation of litigation. It checks all the boxes you need. These are things you also need to think about when you're dealing with these documents. How are you going to get them in? If you have reasonable counsel on the other side, you may just have a joint book of documents that everyone agrees is admissible, and you're just going to fight over weight. If you're even going to fight over weight, you can use a notice to admit, or maybe you do in fact have to start going back to affidavits or viva voce evidence of someone saying, yes, I pulled this from this website, or I went to archives and did this. But you need to think how you're going to get those in and how you're going to get around hearsay rules with all of these records. One thing I saw missing from where to look for documents showing historical roads, water licenses. I don't know if it's in the book or not, but water licenses are more of that, relevant evidence. It's probably not going to say a road is public or private or not, but often attached to water licenses, there's going to be a diagram on the second page or the third page, depending on the water license. When you pull them, they're free online. You can go look them up. If you find water licenses in that area, they will often have this diagram that shows this is where we're diverting water, and it'll show things like lot lines, and it'll show roads and trails and things like that on it. It's just one more place to look. And then the last thing I wanted to address is having a client who's willing to do the work. Bigger issue than you might think. These lawsuits tend to require a lot of effort in terms of I'm going to call it archaeological research, but digging into archives and whatnot and finding all these. It's a ton of work. I can't stress enough that if you're trying to run a private practice, you as the lawyer probably don't have time to do the primary research. And there are times when you shouldn't because you can't otherwise get it admitted. But make sure, I think it's really important from a practice perspective to vet your clients and make sure that they're prepared to put in the amount of work that's necessary for the lawsuit. None of these, I don't think any of these lawsuits are easy. They're all very time consuming. If you're doing it pro bono, it's important to make sure your clients appreciate the work you're doing and are willing to put the time in so that you don't do all this legal work and then they just can't be bothered to get all the research done that needs to be done. There, I was less than 20 minutes. I'm open to questions as well if anyone has any.
Do we have any questions, Jack?
I don't see any questions in the chat yet, and I don't see any hands being thrown up, but
well, Holly, I do think that we should send Morgan a Rocky Raccoon t-shirt. It's long overdue. I remember, Morgan, when you were an ELC student and you testified in the legislature, and your submission was so impressive that you ended up getting, what was it, 2 job offers out of that one?
I did get 1 or 2 job offers out of that. I don't know if they were paying jobs, but they did definitely want me to do some work for them.
Yeah, 2 MLAs came forward and said, yeah, we want to hire this guy. Yeah. Okay, so any other questions? No, seeing no questions, then I guess we.
Can I make a comment maybe?
Oh, sure.
For Morgan, it's kind of a question, maybe he'd want to follow up, but I think it's related to this client willing to do the work, because obviously in our case that we actually started doing the work before we had a lawyer even. So I guess to the extent the guide can help, but anything else, what would you advise people? They show up and then, I mean, the guide talks about team, talks about having people and helping them understand it's going to take a lot of time and work, but they can do it, you know, if you spread it out and different people look in different sources. So, but you need capable people too. It's not, you know, my experience is everyone, you know, everyone is well-meaning, but the best results came from fewer people than everyone, just because some people know how to look and they take the time to look and think about what they're seeing and find what's needed. But yeah, anything that would help, I guess, expand on the guide.
I think the guide's amazing. I also think that if you can hire a researcher, literally hire someone who does this for a living and is an expert and can do it. And if you read some of the case law, you can see some of the cases where people did it themselves and where people had researchers do it for them. If they can come up with the money to hire someone who's trained how to do this and does it for a living, I think generally, not always, generally the results are going to be better. And I agree with Andrew too, that aside from like Nader's Raiders, a few good people is generally better than a lot of poor people. You just need, and then it's probably a division of labors. I try to not get involved in that piece with it. My approach is usually, I want you to present your facts before I agree to take this on, because I don't want to start doing my legal work, which to me is always very involved, before I've got an idea of what my potential client can present. And if they can't do that, I generally say, okay, here's some resources you can use. Now that this guide's out, I can just hand them the guide, which is amazing, and say, here, you need to at least read this guide and, you know, spend 100, 200, 400, whatever, however many hours you need to spend to bring to me the key bits of information. I usually lay out like the groundwork of the law, like this is what we're going to have to prove. And I always tell clients too, it's proof, not truth, right? You're not going into court saying, hey, this is true. It doesn't matter what's true. If you can't prove it, you don't get it. So I don't care what the truth is of the road. Maybe it is a public road. What you need to do is come into my office with everything, the proof that this is a public road. And if they can't, you know, even get through that first stage with some limited guidance, I get pretty worried about assisting, because I don't, you know, I do these generally pro bono. Most of them I do for free. And they're all, I can't imagine I'd do one for under 200 hours of my time. So I don't want to throw in that much of my time just to have them decide it's too much work to do the research on the back end. So yeah, the guide's, I think, absolutely amazing. And that's now going to be my go-to. I'm just going to hand that to them and kind of lay out the law and say, you know, this is what proof looks like. These are the sorts of resources you can use to go get that proof. You go get me enough of, you know, you go get me enough proof for what I'd call a preliminary yes to the case, and then I'll help you further. But I always want them to do some initial work so I don't get burned.
Yeah, that's a great practice point. Thanks, Morgan. I'm also going to highlight that there's two other comments in the chat. One from Deb, who says that professionals who do historical research for Indigenous communities might have moonlighting opportunities researching road histories. So there's speaking of researchers. And the other is from Mark, who points out that Liam's presentation distinguishes between highways and Forest Service roads. And in 2015, the Forest Branch Practices Board said there were over 600,000 kilometers of resource roads outside of the highway system, growing at a rate of 10,000 kilometers per year. And in 2018, the BC government estimated there were 719,000 kilometers of roads with motorized vehicle access in BC. And for context, the Earth's circumference at the equator is only 40,000 kilometers. So BC roads would therefore circle the Earth at the equator 18 times. That's an incredible environmental impact. And Mark points to a couple of links that I encourage people to check out on their own. I don't know if there's further comments on those comments, but I know that we are in the diminishing minutes of our presentation. So
I think we're down to the last 2 minutes. Deb, do we have some information that we need to share about the next associates call? Or okay, well, thank you so much, Morgan and Andrew and Liam. It's just been a terrific session. And I should mention that since we put out the Citizens Guide and we got all the publicity in the Globe and the Sun and so forth, that we've had many, many inquiries. So there are many people that want to litigate this issue. So let us know if you want to collaborate on a public access case. Okay, okay, good.
Go ahead, Mark.
It's always fun to work with you, Morgan. Okay, Holly, do you have any final comments for everybody? Or?
I'll just say thank you. Thank you so much for your participation, and thanks to everyone for being such a great audience.
Bye.
Okay, thanks everyone. Bye.
Bye.